This came at a time the school was rocked by repeated charges of sex crimes. In February, this is what County Attorney Sam Clymer had to say.
You don't have to be sure. You don't have to be certain. You have to have a reasonable belief. Reasonable grounds to know or have reason to believe a child has been neglected or abused or dependent. You're not, by reporting, you're not going to get somebody arrested immediately or get somebody in trouble immediately. What you're going to be doing is calling attention to the fact that this may be going on. I have reason to believe this is happening. A vulnerable member of society has been exploited or harmed or otherwise done wrong, and we need to look into it.
But by March 14th, the charges were dropped and Siglinski was back at the helm of the high school. The letter to the Attorney General says Clymer, faced with public displays of support for Siglinski, like this parade of decorated cars at the high school, interpreted the law in a frightening way. Clymer said the law does not require high school teachers, counselors, and other personnel to report suspected abuse if it's student-on-student abuse.
I cannot find, and my colleague, we cannot find any basis in the law for the interpretation by the county attorney. In fact, it appears to be, I certainly have not canvassed statewide, it certainly appears to be an outlier in the interpretation of this law among counties, at least in western Kentucky. I mean, again, getting back to the core issue, what we're talking about is simply having teachers and instructing teachers to report incidents of abuse. That's all we're asking. But the county attorney says, well, but if it's a child on child, we don't have any duty to report. Not only that, now then one of the school officials who benefited from this interpretation by the county attorney, now that school official has been promoted.
The letter asking for the Attorney General to intervene calls Clymer's opinion that of an outlier and a gross misinterpretation. Clymer is said to be either ignoring relevant case law or is incapable of comprehending previous rulings. It goes on to call Clymer's interpretation of the law bizarre, contrary to the plain language of the statute, and in direct opposition to published case law. Bard says it gives high school administrators a way to bury complaints they may find politically embarrassing.
Cover up, sweep it under the rug, make it go away, you know, whatever term you want to use. That is what their interpretation is of what happened.
Clymer's motion to dismiss the charges acknowledged it was based on what he called a modified interpretation of the law. He said his opinion followed extensive legal research, but also conceded he could find no precedents specifically addressing interpretation of the statute. The letter also says Clymer took the Siglinski case to mediation prior to dismissing the charge for political reasons. It says the mediation with a retired judge was never done before and, quote, was a clumsy attempt to cover up the politically motivated dismissals by the county attorney.
Okay, so Jack, the obvious question is, what does Clymer say about all this?
Well, Jennifer, we went to the courthouse today looking for him, and we even called him, and we were told he's on vacation. And during the call, I was placed on hold at the office 5 times, and I spoke to 2 different people on his staff, and they said Clymer was not able to be reached. And I was told he'll be back Monday and I should send an email to him, which I did, and his reply to that email was one sentence: I have no comment.
Okay, Jack, thank you.